Thousands of residents of Rivers State on Friday staged a protest in rejection of the 8-point peace resolution signed by Governor Siminalayi Fubara and the Minister of Federal Capital Territory, Nyesom Wike, orchestrated by President Bola Tinubu. The protesters occupied the Rivers State Government House main gate along Azikiwe Road as early as 7 a.m. and shut down business activities across some parts of Port Harcourt metropolis. The protesters comprised civil society organizations, Hausa Community Students Union, elder statesmen, and other stakeholders. They warned that implementing the agreement was tantamount to compromising the Constitution of the Federal Republic of Nigeria. The protesters reminded Fubara that Rivers people massively voted him into office and therefore would not allow him to bring the people into disrepute by implementing such an agreement. In the meantime, 6 leaders from Rivers State have dragged President Bola Tinubu to the Federal High Court in Abuja for allegedly compelling Governor Siminalayi Fubara to enter into what they called an unconstitutional agreement. They insist that the said agreement was not only illegal, but amounted to usurpation, nullification, and undermining of the extant relevant provisions of the 1999 Constitution as amended. The plaintiffs, led by a member of the Rivers State House of Assembly representing Bonny State constituency, Victor Jumbo, are Senator Bennett Birabi, Senator Andrew Uchendu, Rear Admiral O.P. Fingesi, Ann Kyo Briggs, and Emmanuel Dienma. They are consequently praying the court to determine whether President Tinubu, Fubara, and the Rivers State Assembly have the right and are entitled to enter into any agreement that has the effect of nullifying or undermining the Constitution and provisions of Section 109, subsection I, G, and 2 of the 1999 Constitution as amended. Joining me on the news to discuss this is legal practitioner, National Legal Advisor, Committee for the Defense of Human Rights, Henry Ekine. Hello, Henry, and thank you so much for joining me this afternoon. Henry, can you unmute your device? Okay, yes, I can hear you now. All right,
yes, thank you for having me. It's my pleasure to be here.
It's a pleasure to have you as well. Now, taking a look at the underlying reasons behind the widespread protests in Rivers State, particularly regarding to, the perceived presidential intervention in the state's political crisis. What specific grievances or concerns are being voiced by the diverse groups participating in these protests?
Well, let me begin with this common position of the Constitution. Sovereignty lies in the people from whom government derives its power. So the people of Rivers State who really constitute the beneficiaries or otherwise the victims of any action of government or anybody in any authority, whether at the state level or at the national level, are simply expressing their position. And then if there is any reasonable and responsible person and authority under a constitutional democracy is to listen to the voices of the people who indeed are sovereign in a constitutional democracy. So the Rivers State people and residents here have actually received that purported agreement with mixed feelings and, of course, reservation and rejection to a large extent. And the principal ground is that these are issues that pertain to provisions of the Constitution and, of course, of law. And so citizens of the Federal Republic of Nigeria, anywhere, whether at home or in the diaspora, are enjoined by the Constitution to observe and protect the Constitution of this country. So I think it's a simple demonstration of that civic responsibility by Rivers residents and indigents, and even the elders and other stakeholders in Rivers State and across the country, all of those citizens of this country who uphold the provisions of our Constitution and take steps to protect have really been averse to the provisions or the clauses in that purported agreement. And that's just the reaction. So back here at home in Rivers State, and I join in my voice with those that have gone out protesting yesterday and those who have been speaking in condemnation and in rejection of those clauses, is that all we are seeking is that every authority including Mr. President, the legislators, the governor, and the minister must uphold and protect the provisions of the Constitution. More especially, these are public office holders who have sworn to the Constitution, sworn on oath to uphold and protect the Constitution. How else do you protect the Constitution other than be guided by the principles and the provisions of the Constitution? If you go against the principles and provisions of the Constitution in any consideration, then you are not protecting the Constitution. And those who purportedly were in that meeting, and then even the clauses as your screen, are simply in contravention with the provisions of the Constitution. And I'm afraid those authorities of state are violating the provisions of the Constitution in those regards, specifically with respect to Section 109, subsection 1, paragraph G, with respect to the powers of the governor to appoint commissioners without any external interference, apart from the requirement of Constitution, that those commissioners appointed by the governor shall be confirmed by a House of Assembly. And again, against the provision of the Constitution to the effect that when a law reasonably made in a democratic society and has gone through the process and stages of lawmaking, as the appropriation bill in Rivers State has gone through the first reading, the second reading, the committee stage, perhaps a committee of the whole in the Rivers State House of Assembly, and then the third reading, and even transmitted to the governor for assent. And the governor has assented. It has become a law in a democratic society, and then somebody would decree somewhere and direct that without a repeal. Let me dare say that the only way a validly made law will be pulled down, it is where the validity is contested before the court. And the only powers vested in the court, pursuant to Section 6 of the Constitution, is to verify the appropriateness of that law, particularly with its consistency.
All right. So what you're saying,
legal issues, really.
All right. So what you're saying is you're positive that the court would actually rule in favor of these Rivers State stakeholders that have, taken the president to the federal high court. But what if that doesn't happen? If reverse ends up being the case, what next?
Well, one wouldn't expect that. That would be a dangerous optimism, really, for one to, or rather, a dangerous step for any judiciary to take, because even the judicial officers have sworn to an oath to protect the Constitution. So I make a presumption in favor of the Constitution that no judicial officer will turn the Constitution otherwise and suspend the Constitution as the participants in that meeting had apparently done. I do not expect a judicial officer will look the other way, because it's a simple interpretation of the provisions of the Constitution, that if the Constitution has said this, then any other person who has gone the other way has gone inconsistent and in contravention with the Constitution. And then the Constitution has also vested power in the judiciary to be invited, and the jurisdiction of the judiciary to be invoked in this regard and activated to give interpretation to the provisions of the Constitution. And let me say that this is not the first time. The courts have spuriously, and then in a number of cases, interpreted the provisions of the Constitution. All of these sections, particularly Section 109, has been spuriously interpreted up to the Supreme Court. So it has become both a constitutional matter and a judicial precedent. So I do not think that any judge at a trial stage will hold otherwise. So, but it's just that it's unfortunate that the political office holders have taken this really disturbing position. And that's why those elders and then the parties in that suit have approached the court. We need not get to this point where anybody would go to court again to seek any interpretation of Section 109, subsection 1G. And then we also do not need to go to the Constitution to seek interpretation with respect to the powers of a governor to appoint commissioners, or with respect to the powers of a House of Assembly to make law. Let me state one thing, that there are positions of law that are referred to as what we say in law, taking judicial notice, meaning that every judge in this country must have taken notice to the effect that a validly made law, let's say in Rivers State, a law that has been made by a Rivers State House of Assembly ought to be in the knowledge of every judicial officer in this country. A law that has been made by a House of Assembly in Gombe, being a validly made law, ought to be in judicial notice of every judicial officer in Gombe and across the country, let alone the provisions of the Constitution. That is presumption that every provision of the Constitution is known to every judicial officer. So judicial notice is already taken with respect to these provisions, including decisions of the Supreme Court. So it's really disturbing that we're at this point. But as a lawyer, I cannot discuss beyond this and get into the merit of the matters in any subsisting matter. But to just explain the provisions of the Constitution as they stand, that we can do at any time.
All right. Speaking as someone, a resident of Rivers State, there's no doubt that this particular crisis has actually opened a lot of loopholes and also gaps when it comes to democracy and all that. But how do you think that this mass demonstration or the crisis in Rivers State ongoing right now would influence the political terrain and also decision making of Rivers State?
Repeatedly, I've emphasized that the first that really would be affected by all of these are the Rivers people and residents here. And then democracy is another victim with all of these orchestrated and avoidable skirmishes. Democracy is threatened, if not already murdered, in Rivers State. And then the mandate of the people is also threatened. And again, the very expectation and then aspirations of the people in this regard are also being affected. And what is this? Fundamentally, Section 14 of the Constitution is basically laying the foundation with respect to the aspiration of the people in any democratic society, where government should be focused on one agenda to continuously enhance the welfare of citizens, and a second agenda to continuously ensure the protection of lives and property of citizens. Now, when you have distractions that have actually engulfed the governor of Rivers State and his cabinet and the kind of upheavals that already now challenge the Rivers State Executive Council to implement the provisions of law, and then even the legislature to make laws for good governance in Rivers State, then the victims are actually all residents in Rivers State. And then, of course, like I said, democracy, good governance, sustainable development, the economy of Rivers State, all of these are serious challenges. I'm afraid that in the last 1 month, since October, that the governor has not quite been focused with respect to delivering good governance. And then talking about, even though he's struggling anyway, I must commend the governor, he's struggling in any way that in the midst of this,
with that, we actually do hope that, this crisis comes to an end very soon so that the governor can actually focus on, leading the Rivers State to greater heights. But thank you so much for joining me on the news. Henry Ekine, legal practitioner and National Legal Advisor, Committee for Defense of Human Rights. Thank you so much.
Thank you very much for having me. It's my pleasure.